You're coming up here, right?
Yeah.
Okay.
Okay. You know the chair then? Nope.
No,
All right.
I'm gonna stand.
You stand. This way she can say she towers
Right, I
over me.
tower over you. For
Okay.
this purposes only.
Good stuff.
Let me move that. Nice stuff.
No, you're good. No, you're good. Just leave it there.
Legroom.
She's worried about me rooting through her purse next.
That's right.
That was the truth.
All right. Good morning, or good evening, and thank you for joining us tonight. With us tonight for our guardianship training is Medina Judge Dunn and Magistrate Alicia Hathcock. Thank you for those that are joining us online as well. At the end of tonight's presentation, we will have opportunity for questions. If you are joining us virtually, you'll have an opportunity to ask those questions virtually if you choose to do so. So I'm going to turn the table over to you.
Do you want to
Go ahead.
introduce yourself, Judge?
I'm Kevin Dunn. I'm the judge of the Medina County Probate and Juvenile Court. I've been in that position since August of 2013, and I have the oversight. I am the superior guardian of every person under guardianship in Medina County, and we have about 890, something
Somewhere
like
in
that.
there.
Yeah,
Yeah.
of individuals under guardianship that we are entrusted to make sure everything is taken care of for them. And it's been a great run. I have a great magistrate, actually several great magistrates, but the one I brought you tonight can really knock it out of the park. So we're going to cut you loose and we'll give you a presentation. And feel free, any questions you may have, this is a great time to ask them because you don't usually get to walk into the court and say, hey, what's this question? What's that question? And we're always trying to be helpful to people. If you have ideas or suggestions for us, we're pretty open to hearing them and trying to act on those as well too. So pass it over to you.
All right, so I'm Magistrate Alicia Hathcock. I work for Judge Dunn. I've been there 7.5 years. Everyone always asks what's the difference between a magistrate and a judge. He is elected. I'm appointed by him, so he can fire me whenever he likes. But we actually have the same requirements. We're both lawyers and have the same continuing education. We'll wear the black robe. It's just if you disagree with me, you go to him, and he has to decide if I'm making the right decision or not. But I'd say both of us have served as guardians before.
Yes.
When we were in private practice, and there are some attorneys that do that serve as guardians. I've served personally as a guardian over dozens of individuals of all different types. People who had mental illness, people who had developmental disabilities, and the elderly. And I know the judge has done the same. So we come at it from some practice experience and then also, come at it from the court. So we're going to talk about what is a guardian, how do you get it, what are your responsibilities, and at the end we'll talk a little bit about some alternatives that may be available to you or may not. Okay, so the first slide we'll have, how do we get there? And that's what the law says. Basically, when you're 18, you are capable of contracting and are a full age for all purposes. So if you can do it as an adult for the most part, when you turn 18, your loved one gets to do it as well. So there's a couple of the examples, right? So as soon as you turn 18, the day you're 18, you can enter into a rental agreement. You can go lease something. You can go buy a car. And if you don't think your loved one can get a car, you're wrong. I have seen disabled individuals who make $800 a month get car loans without a cosigner, 18% interest, but they'll get them. It's a little terrifying. And credit cards, student loans, they can have access to their bank accounts or any other financial account. They can refuse providers. They can add providers. They can refuse to work with the county board. They can cancel their waiver if they'd like without a guardian who's making these decisions for them. They can make educational and employment decisions, can make medical and treatment decisions, okay? So basically when you're 18, you can do whatever an adult can do unless you have a legal disability, and that's a guardianship. So that's why you have to come and get a guardian. 18 is that magic dividing line. Okay, so what is a guardian? It's someone who's appointed by the probate court to have the care and the management of the person or the estate of an incompetent individual called a ward. Okay, so the guardian is the person in charge. The ward, we lost the link, is the person who is under guardianship.
We now like the, in the new nomenclature, it's person under guardianship versus ward. But person under guardianship, it's like filling out Westfield Center, Ohio on your block when you go to tell them what your address is. You run out of space. And we have referred to it as being a ward for so long. We just go with that. And that's our typical response is your award of an
It's
individual.
not unusual though for me. If sometimes my decisions will refer to the, instead of award, they'll say Miss, Mr., or whatever the person would like to be called, right? So if someone wants to be called Bob, and I'll ask them sometimes if I have the ward come into court for a hearing, I'll ask, how do you want me to refer to you? And that's the name I'll put in the decision, or that's the name that I'll refer to them by, whatever that may be. Okay, so
So I apologize.
That's okay.
Student update. So if you
Oh,
can-
no problem. We can keep going.
okay.
One of the things you'll note, if you ever come to our court, if you're ever in front of Magistrate Hathcock, her courtroom is set up very similar to this kind of room. It's one level. Typically a court, there's risers and there's heights, and that was instrumented to say that you are not above the law. And it can sometimes be very intimidating for people, individuals who may be a ward coming to that environment. Oh my gosh, there's this big scary guy that blacks out the sun sitting up there, and he's 3 feet ahead of me, and it's like being preached down upon. So we've made a point, and the magistrate's done a great job, and we're planning for our new court building as well too, to have these types of hearings being held in this type of environment where it's more of like we're all on equal terms. Let's try to get some semblance of evenness here, and no one's trying to pull anything over on you. So that's something that we strive for, kind of perception when you come in of what you're going to be getting.
Yeah, absolutely. My courtroom's set up differently from everybody else's actually in the building. It looks like a conference room. You see a table. I have a desk. I don't have the riser. It's not uncommon for me. If I'm doing a hearing with someone who can't hear well, I'll move in front and do the hearing right there. I did a hearing with a karaoke machine because it was an elderly person who could not hear, just couldn't hear. And unfortunately, our courtrooms right now are not wired for that type of equipment. And I don't know why we had a karaoke machine, but we did. Sorry, Judge, I'm not really sure. But we did. So literally, I had the karaoke mic, and it worked for that person. They could hear me. I've also done things, I wear a black robe like a judge would. That was very intimidating to some people. I'll take it off. If that's making somebody nervous, I'll take it off. I will also say not uncommon, either for behaviors or maybe somebody on the spectrum, they need to walk around, they got to move, they're moving, they need something. That's fine. We will work with it. I will turn the lights down. Everyone likes to bang the gavel. We can bang the gavel. We'll just make it work. It's just the way it is. We're pretty flexible with that. And most of the time you are in front of me. I mean, 99% of the time you're going to be in front of me. So we will do what we need to do. So again, a guardian is that person who's in charge of the care. Okay. The incompetent person or the ward, there's a definition about that. Okay. And that's what the court looks at to determine whether they need a guardian. It is a person who is so mentally impaired as a result of a mental or physical illness or disability, a result of an intellectual disability, a result of chronic substance abuse, that the person is incapable of taking proper care of their self or their property. So what we're talking about is someone who's mentally impaired. We're talking about cognition, mental status, okay? So that is generally who we are looking at, who would be incompetent. So do you want me to let this, are we still a few minutes away?
Yeah, we could.
We're working on it. And just, there we go. Just going back to 18, if you noticed, it didn't make reference to anybody's. It said when you're 18, you're not under, you can do all these things. It doesn't say you're on the spectrum. No, you don't get those powers, or you have a developmental disability. There's no automatic that says you need a guardian or you don't need a guardian. Kind of makes sense if you think about it, right? People are on, I mean, you have varying levels of conditions. So I get that question a lot. You know, my person is so profoundly disabled, they can't even talk. Why do I have to come and do this when they're 18? Well, that's what the law says.
Yeah, the law opens the door at age 18, just like it closes it for juveniles that don't have the right to contract before 18. And that's why I have all these people coming in for, like, for example, a minor settlement. If a child gets injured, they have to come before me and I have to approve that settlement. And parents are like, why do we have to come to see you? We're the parents of this child. And I have that opportunity to explain that to them. I said, well, that's kind of that superior guardian thing for me. Not that I have a superiority complex and want to try to give you a hard time, but we do have some situations that's important that the parties understand that. So it's kind of a dual situation.
It's a definition of a guardian again, incompetent again. We're talking mental impairment, cognition, mental status. Okay, so there's two types of guardianship powers. You can be guardian over the person, you can be guardian over the estate, you can be guardian over both, okay? So guardian over the person is the protection and the control of the person of the ward, right? In general, we're talking about medical treatment, we're talking about where somebody lives, their person, their physical well-being. And that's what a guardianship over the person is. It also entails, and this is a newer one and kind of a controversial one, would be visitation. Who gets access to your ward? They've actually just written that into the rules. There were some courts that said, hey, we can't touch that in a guardianship. They've made it clear that we can touch it in a guardianship. That's always done in the person's best interest. But that is something, as a guardian, you may have to put on restrictions for the safety of your loved one, who has access to them. Then we have guardianship over the estate. That's money, property, assets, okay? You're managing that person's estate. You're making financial decisions for them. I will tell you there is many more filing requirements, a lot of paperwork, a lot of accounting to the court. It's usually not necessary for a developmentally disabled person who is primarily only receiving Social Security, okay? Generally, you don't need it. Social Security has their own program outside of guardianship called a representative payee. They determine who gets to handle the money, which is almost always the guardian, and they have their own program of how you account to Social Security, okay? So you generally aren't going to need guardianship of the estate for a developmentally disabled person, most of the time. You can have co-guardians. You don't have to just have one. So you could have a guardian over the person and have a different guardian over the estate. You could split those responsibilities, or you could have two people over each. I will say some courts do not allow this. We do allow it, as long as you can get along. So especially if I have parents maybe that aren't together, or maybe it's like a parent and another child that wants to be guardian, I'll ask them, you know, can you get along? I will tell you can get a little unwieldy because some of those doctors want both signatures or want both people there at the appointment. So just be careful if you're going to add. You may be increasing your workload. And again, some courts don't allow it. I haven't done more than two. I think when you get over two, you're going to have some problems.
The ones that I've seen have been, for example, maybe two brothers stepping up to be guardians, and one may be a financial planner, and you take over the finances, you be the guardian over the estate. And I'll be, because I live here right on top of this person, I can get them to and from all the appointments, everything they need to do. That's kind of how we look.
Or very common to have parents as a co-guardian over the person of their loved one.
Yeah.
Very common. The probate court is a superior guardian. That's a little bit of what the judge is saying here. The probate court gets to make the final decision. So we are vesting the authority into the guardian, but if there's a disagreement, the court will make the ultimate decision. And we have. We try not to, but there are times where we've had to intervene, usually for an extreme health, safety, welfare of the ward. Generally, I will tell you what happened. One in particular, I had a guardian who was literally on like a transatlantic flight. They were on some flight that was 12 hours in. Their loved one, their ward, needed emergency surgery. I think it was like an appendectomy or something like that. It had to happen now. There was no waiting. Couldn't get a hold of the guardian. So what do? The hospital called us. We made the decision and consented to the surgery. It's because we're the superior guardian. Okay. Say anything more about that, Judge?
It doesn't make people happy. It doesn't make us happy to have to do that. But those are the things that come in the middle of the night, something grave to do it. We do not go out and try to search down situations to insert ourselves. Also, being the superior guardian, that's part of the process. When you do your accountings and things like that, if you're a guardian of an estate, part of my job and our magistrate's job and our court's job is to make sure those funds are being applied for the best interest of the ward. And that's why we're there, because it's sad to say, but we do have people that try to run off with individuals' monies. It's not uncommon, unfortunately.
The guardianship powers can be limited either by time. Maybe you only need something for a certain amount of time. Very typically, maybe you only need guardianship of the estate to create a special needs trust. Maybe your loved one, gets a personal injury settlement, and you want to create that special needs trust and it's not already in place. We can do a guardianship just for a sole purpose, and then we let that go. Always trying to keep down your paperwork, always. So you can have limitations. So how do you start it? Okay, there's an application process. It can only be filed in the probate court. We are the only court with jurisdiction. It's filed in the probate court of the county where the proposed ward is a resident. Basically, it's where are they now and do they intend to stay? All right, where are they laying their head at night? They can get a little tricky. Sometimes we have out-of-county placements, right? If someone is in an ICF or in a group home that's not in county, maybe it's only for a temporary purpose. We'll determine that at the hearing, but most of the time, if they're still receiving services in this county, we can go forward with the guardianship because it's like a temporary placement. I mean, yes, that's where they are now out of county, but they're just getting care. It's not designed to be forever, and we can go forward with it, okay? And I think the judge was saying, you know, we have at any given time between 700 and 800 cases, open cases. We have cases from as far back as the 60s, people who have been under guardianship since the 60s. And it runs a gamut. I don't know what the actual statistics are. I would say probably at least 40% or more of our cases are developmentally disabled individuals or some type of intellectual disability. Probably another solid 30 to 40% are elderly, dementia issues, memory problems. And then we do have mental illness as well. That is typically would look like a schizophrenia or a bipolar. And of course, we could have people that have a dual diagnosis. You could have a mental illness on top of having a disability or dementia. So they overlap. But the majority of our cases are either just developmental disability or elderly.
We also, just comment, that's the filing or instituting of the application process. We do accept individuals. I get contacted all the time from judges in other counties saying, hey, I have this ward who is relocated to Medina County. Will you take over the guardianship of them? Because why should they have to come back to Crawford County when everything's in Medina? That's a pretty regular thing for us, and we address those very, very quickly, and we try to get moving on those because we want to know this new person who's kind of that I need to make sure is being taken care of. And that judge in Crawford County, for example, doesn't want to have to drive all the way up here and make sure that person's being taken care of too. So it works out that way.
Yeah, we get a lot of those cases because quite honestly, our county has amazing services.
Yes.
People want to be here for the services. We get a lot of transfers in, people who wait for some of our facilities to open up. So it's something to know if you're from this county and you have a placement and it opens up, realize and I understand it'd be really hard. Like, do I make that decision right now? Or maybe I want to keep them with me a little bit longer. Just know the next time you make that decision,
may not be there.
We are placing people as far away as Youngstown, Southern Ohio. I mean, it's a care crisis situation. So our county is amazing. Our services are amazing. People want to be here. So we take the cases, we get them constantly because finally something opened up. So part of that application process is there's people who are entitled to notice, okay? So who's entitled to notice of the hearing? So you file the application, it's going to get set for a hearing. Who has to know about it? So the ward, if they have a spouse, they have to know about it. If the ward has children, they have to know about it. Then we go to the parents, okay? So this is kind of going down. If you don't have a spouse, the next question is, do they have children? If you don't have children, then we're looking at the parents, okay? And it's both parents. Because I get a lot of those that maybe a mom or a dad or another family member says, mom and dad haven't been involved forever. Well, the law says they get notice. Unless their parental rights have been terminated, they have to get notice. So you're going to have to do some due diligence to try and track them down. And if there's no parents alive, then we're looking at the siblings of the ward, okay? They're going to have to get notice by certified mail unless they waive it. So you have like the technical requirement that can sometimes tie up a hearing. It's also why we normally set our hearings about 4 to 6 weeks out from when the application is filed. Because normally we're going to have to get some certified mail service on some people. Now, if it comes in and you have waivers from everybody, you know, that's at the table, we can move it quicker. So the next step, all guardians are going to have to undergo a criminal background check. So a conviction of a crime is not automatically going to disqualify you from serving as a guardian. A lot of people are getting nervous about their old DUI when they were 21 or 22. That's going to show up on the criminal background check. Normally not a problem, but I have to consider it, okay? So you're going to get a criminal background check, and you'll see what I have to look at is, has that person been charged with or convicted of a crime involving theft, physical violence, sexual abuse, alcohol, or substance abuse, okay? You also have to disclose if you have anything pending. I'll ask the questions at the hearing. I know it can embarrass some people, and it's not meant for that. The law says I have to look at it. A DUI, OVI would be a most common one. Generally not gonna, preclude you from being a guardian. If you have 2, 3, 4, you don't have a driver's license, you had one pretty recent, we're going to have a conversation, right? Because I'm going to want to know, are you driving your loved one? Do you have a valid driver's license? Are you under probation, right? So there's going to be a conversation. Domestic violence assault. That's a tough one as well, right? Who was the victim? If you are victimizing children, disabled people, your loved one that you're here trying to get guardianship for, you're going to have to explain that. How long ago was it? What were the circumstances? And sex offenses, those are even harder. Because that's gonna, if you have a sex offense, you may have trouble even getting access to a facility. So those are some, I would say the domestic violence assault and the sex offenses, those are the ones you're really gonna have to prove that you can be a good guardian, and it's not gonna impact the care of your loved one. I mean, that's really what it's about, right? It's the care of your loved one, the care of the ward. I need to know that you can fully do that job, and your issues, past or present, aren't going to affect that person. And I'll say it in a hearing. Everyone, I'll hear everybody's kind of dirty laundry in their family. I'm like, I don't really care. I care about your loved one. That's who I care about.
Other question you may be asked is, have you ever changed your name? That's becoming a very popular item. I think by Mondays and Tuesdays, I probably have 6 or 8 of applications daily that come in. And part of that is we want to make sure you are who you say you are. I'm Bob Smith. Last week I was Bob Jones and I was robbing banks, but I've changed my name. And you're because you're offended by that. Why are you asking me these questions? And as Magistrate Hathcock said, we have to do this for what's best for the ward. So that's where we're digging down a little bit.
Yeah.
So.
Part of that application process, you're going to need a statement of expert evaluation. This is a very particular form that is, I think it's about 4 pages long. It needs to be completed by a licensed physician or licensed clinical psychologist. We prefer the original signed document, but the reality of medicine is those are getting a little few and far between. So if you can, we would love to have the original. If you can't, we understand that. And just make sure it's completely filled out. Now, the reality of medicine is, I don't know that I've seen an MD in 5-6 years,
Nurse
right? We're all saying nurse practitioners, physicians, assistants. They are currently trying to change the law, but it's not changed yet.
Yeah.
So you're going to need that MD, DO, or a PsyD, a licensed clinical psychologist. Okay.
Get on your health app on your phone or whatever and send that to the office. SUMA, all of them have something like that and say, here's what I need. You'll be surprised if they don't have to see you, how fast a doctor will have something signed as long as they don't have to actually have an appointment with you. An appointment with them will be a year from now, but you get the nurse practitioner that afternoon. But if they need something signed, they'll get on top of that pretty quickly.
Well, and the nurse practitioners and the physician's assistants are supervised by a physician. And that is, so it's not uncommon for us to get an expert evaluation with maybe both names on it. And as long as I have that doctor's name on it, I'm okay. I'll go forward with it as long as they are attesting to that. So then you actually have a hearing. Okay, so we have the application, we've got service, we've got all this paperwork, you've done your criminal background check, we've got the expert evaluation, you actually get to the hearing day, okay? So just so you know, you can file that application prior to someone being 18, but I can't hold that hearing until they're 18. It's actually pretty common. I hold a lot on the day the person turns 18 because the parents or the loved one wants to make sure there's no gaps, right? Between being parent and then all of a sudden your kid's 18 and you've got no authority anymore. So let us know. We will make it happen, okay? And again, we're about 4 to 6 weeks out. Let us know. If you have an upcoming appointment that you really know you need authority for, you have an upcoming procedure, your ISP is set, your big meeting's coming, we'll make it happen. But you got to let us know. That can be as simple as picking up the phone. We have one dedicated clerk. Her name's Leslie. She's amazing. And she'll let me know and we'll fit it in. Okay. The next piece, we have a court investigator, and this is by law. This is not something we do. The law says, so we have a court investigator who will go out to your house And she is a social worker. Again, this makes people nervous. They think children's services is coming to their home. Nikki is not children's services. She is a social worker. So by law, we have to have one of these. She tells the proposed ward, your loved one, somebody's filed for guardianship. Here's your rights, because believe it or not, they have rights. Okay. The proposed ward has the right to have their own attorney. They have the right to their own independent medical evaluation. They have the right to disagree. Doesn't matter why. Doesn't matter what their cognition is. If they say it, they're getting it. And if they can't afford it, the court pays for it. Now, you won't get court-appointed counsel, right? The guardians don't get that, but the ward will. So she tells the proposed ward their rights, asks them if they want an attorney, asks them if they want an evaluation, and then she'll ask some questions. And she has a maybe 6-page form. She's looking at their functional capacity. Can they feed themselves, dress themselves? And then some of those instrumental activities of daily living, can they pay bills? Can they drive? Can they cook? And that all comes in a report. And she does make a recommendation to the court that the court has to consider about whether there should be a guardian. So you are allowed to see that report. You have to physically come in and see it because it's actually confidential. It's not a public document that anybody can come and see, but you can see it if you come to the court and you're a case party. Okay, so it's required by law. The report's required by law. But she makes people nervous, even though she is probably the sweetest person I think I've ever met. So
yeah,
she's really a good person.
Yeah, she's super.
Yeah. So then we get to the actual hearing date. You're coming to court. We are mostly doing our hearings in person. That can be flexible at your request. If you have a concern about COVID, your loved one is medically fragile, just let us know. We will do that by Zoom or any other concern you have. Just let us know what accommodations you need. If someone's not comfortable, right, at our current courthouse, you sit in the hallway with a bunch of other people waiting for hearings. If that's going to be a problem, let us know. I'll make sure you come right into the courtroom and keep it quiet and kind of relaxed. The proposed ward has the right to be present. If they want to be present, they're going to be present. And they can have anybody there they want. Doesn't matter to me. So let's say you're appointed guardian, what happens next? Okay, so if you're guardian of the person, your very first filing is 1 year from the date you're appointed. You're going to be filing a guardian's report with another statement of expert evaluation. That's that report that was filed by the doctor, okay? So you're appointed, this is 1 year after. Now, if that doctor says that your loved one isn't going to improve to the point where they're going to get off of guardianship, there's a little addendum they can sign. And generally, if the doctor signs it, then you don't have to file expert evaluations anymore, which is important because you don't have to chase down a doctor for paperwork. But you're always filing a guardian's report. Guardian's report is, where is the ward living? How many times have you seen them? Have there been any major changes in their condition? You're also filing an annual plan. Okay, this is 1 year after you're appointed. Lets us know what are your goals and your objectives for your loved one. Also lets us know if you've put on any restrictions on visitation. That's a new component. So if you're guardian of the person only, doing the medical and placement decisions, you're filing a guardian's report and an annual plan. If you're in charge of money through the court, you got a lot more going on. And this is kind of where I told you. So your very first filing is you're filing an inventory. So you're appointed. Within 3 months, you file the inventory. Inventory is a list of the assets. It's like the very first line on a checkbook ledger. What do you have? You may be ordered to post a bond. Now, this isn't a criminal bond. It's not like I'm going to say put $1,000 with the court. This is like an insurance policy that says if you were to misspend the money or do something wrong, the bonding company would pay for your wrongdoing. The application to release funds is an order telling the bank to allow you to have access to the money. The application to expend funds is, hey, court, here's what I want to spend the money on. Basically, you're going to create a budget off of the inventory, the application to release funds, so you can get access to the money to fulfill that budget, and you have to ask to spend money before you spend it. That's the application to expend funds. Okay?
And we're pretty liberal in looking at the application for funds. This person needs, we want to take them on a trip. We want to buy, we're going out to a family reunion. Here's some of the expenses. get that to us. Those things come across my desk very quickly, and I look at those and I get those things out very, very quickly. The concern sometimes we have is this really for the ward, or is this for the guardian, or is there a purpose that the guardian's having money spent on their home, their residence? Does it benefit the ward in some way? We have to kind of go through this, but we make very quick decisions on those. And it's just a kind of a bookkeeping regimen. The bond, I don't think we've had to call up too many bonds in guardianships, but it's a insurance policy for the court to ensure that, okay, this person's going to do their job. And if they don't, the insurance company is going to pony up and make this right by the ward, and they'll deal with the guardian that acted inappropriately, go after them as needed. Okay.
And then every year you're filing an account. Your first one's due 1 year from appointment. And that's just what it sounds like. How much money you took in, how much money you spent. It's a checkbook ledger is in essence what it is. You're going to give us all the bank statements. So you can see why we try really hard to make sure you don't have to do this. Okay. It is time consuming. It's a lot of paperwork. It's generally not necessary for a young person with a developmental disability just getting Social Security. Where we typically have guardianships of the estate are with older folks. You will also have to undergo some training. Now, there was a lot of changes to the law back in, I think it was 2016. And the Supreme Court says we want every new guardian to undergo 6 hours of training to start with, and then 3 hours every year thereafter. We're not doing that. Quite honestly.
No.
We're not doing that. So if you are related to your ward by blood or marriage, we have a local training class that will take a maximum of 1 hour of your time as opposed to the 6 hour one. Okay. And it's online. You don't even have to come to the court for it anymore. We give you instructions on how to access it.
Not that there's anything wrong with the Supreme Court's programs that they put on by video. And I welcome you to go look at those. But the problem was they became stagnant. And so they've come back, and pre-COVID, I was going down to Columbus at least quarterly for probate related matters and discussing these types of things. And they're trying to put together different topics that you as a guardian may have come across and you may want to have some additional information on. So it's an excellent resource, but from our end, we have a lot of people that really lost it when the Supreme Court mandated everyone had to go to Columbus, actually, when they first came down with this. I said, I have people up here in Medina, Ohio, and I fought pretty hard against that. And finally, someone from the Supreme Court says, well, it says this. It's not like we're requiring. I said, it says shall. It doesn't say maybe. And I said, if you're telling me your idea of shall is maybe, then my maybe is maybe my people ain't going. Okay. And that's how we kind of came up with that decision.
It is. We're not going to send you. And for the majority, this is what you've been doing. You've been caring for your loved one.
Absolutely.
All their lives, however long that may be for the most part. That's your parents. That's your child or whatever, niece, nephew. For the most part, this is not a stranger to you. This is everything you've been doing. It's just putting it, you have to come to the court to get the piece of paper. Some people would say it's like a marriage license, right? You may live together as husband and wife, but you need the piece of paper.
Speaking of marriage, remember we were talking about.
Yes. So
marriage is one of those things that terminates a guardianship. It's a determination that the person's competent. And we were talking today about it. I had an individual that was stealing cars on the Burbank line of Medina and Wayne County. And he was found not competent to be able to be criminally prosecuted. He would just take a car from this place. If someone would fill their gas tank up, he'd take it and go. And, the guardianships were established. And the next thing I know, this guy, someone's married him, and it terminated the guardianship. So for those of you who have wards, that's part of the reason association, who you allow someone close to your ward and not to. The person was clearly taking advantage of this person, but it really threw a curveball at two judges who were trying to pass this person like, okay, he's your ward because he got caught in Burbank, and that's across the Medina line. And the individual was actually homeless, living in a tent at a place right there by the truck stops. And he would move, and he would tell you, nope, when he knew enough to say, when he was in Medina County, nope, I live in Wayne County. You got me in the wrong spot. He worked us pretty good, but it's just one of those things. We bring that to your attention. That's part of the reason some of these processes are put in place. You look out the best interest of your ward.
Occasionally guardians will call us and say, I'm worried my ward is going to come up and get a marriage license. We'll take their name and it's like right there at the window. We've had them show up.
Yes.
Yeah. So.
Yeah, care provider.
Yeah.
Try to bring someone.
Yeah. Okay, so now again, you're appointed. We've gone over the paperwork you're gonna have to do. So like, really, what is your job? Okay. All the decisions have to be made in the ward's best interest. That's the overriding principle. You have to take into account the ward's wishes. It's ward-centered planning. You at least have to listen to them. I will tell you that does not mean you have to agree with them. You have to listen to them. You still ultimately have to make the decision that's in the ward's best interest. And that's in anything, money, medical, whatever. You listen to them, but you still have to protect them. That's best interest, okay? You'll be responsible for monitoring and coordinating all services and benefits and maintaining eligibility. I mean, that's in the rule. If you're guardian, you're going to make sure they've got their waiver, they've got their Social Security, they're connected with Medicaid if that's what they need to do. I'll tell you, the waiver, developmental services is a big one, at least with me. I have some people that I don't need the waiver. Oh no, you need the waiver. Like you're gonna really, I don't know that I've ever approved that.
No.
That will allow someone to lose the waiver. That's not in your person's best interest. Maybe you have a personality conflict with somebody, but that person needs those services. You have to have that in place. Or canceling services with the county board. By rule, you got to keep them. And if you're going to tell me it's not in that person's best interest, I would almost guarantee you're going to get a hearing and have to explain that to me. You have continuing reporting responsibilities to the court, again, court superior guardian. So we have to know, is there an abuse, neglect, or exploitation situation by a caregiver, by another family member, by somebody in the community? Whether the condition has improved. We terminate guardianships. It happens where someone, maybe they need a little bit more time to mature. Maybe their condition changes. Maybe you get enough services in place that you can go without a guardian. We can terminate that. Nothing's forever. If your loved one dies, if there's a change in residence, you should notify the court in advance if possible, and if you're moving to a less restrictive setting. So let's say you're going from your own home to a group home to an ICF, or from, if it's an elderly person, from their home to a nursing home or assisted living. You have to ask for authority from the court to do that in advance if you can, unless it's a health, safety, welfare. And again, these would be like permanent moves. If it's just a respite placement or you're trying something out for a month or two, that's not permanent. When it becomes permanent, you have to let us know. You have to ask or let us know that you're going to file a lawsuit. Likewise, if you're going to create a special needs trust, there's one not already in place, you ask the court for authority to do that. Big question, guardians serving as paid providers. We are very aware of the just absolute crisis in direct care providers right now. They're non-existent, right? So technically the law says it's a conflict of interest for you to be the guardian and to serve as your loved one's paid care provider. The court will waive this conflict. We actually have a form. And if you're related to that person, we will waive that conflict. What we're always, I would say, questioning, if somebody is not related, wants to be guardian, and they're already a provider, and we get these, can you see the conflict? This person, their paycheck is coming because of the services they're providing. And now I want to be in charge of all the medical. I want to be in charge of that person's financial. It's almost like biting the hand that feeds you, right? So I'll ask them, if you wanted to terminate your own services, could you do that? Oh, yeah. But that's the person who's paying your paycheck. There's the conflict. So, but when it's your loved one, and this is typically a parent providing for a child, we'll waive that conflict. And I would just mention, you, as a guardian, you can't receive any incentives or compensation from a direct care provider. What that means is, hey, come with me. Your guardian, you get to make the direct care choice. Come to my agency, and I'll give you a $500 bonus. You can't do that. That you can't do. But we'll approve waiving the conflict of interest, allow you, usually this is the Ohio Shared Living Program or the OSL program, right? That's typically why we're getting these. And the order will just be, you're subject to the requirements of that waiver program.
And there's usually an inquiry bias as to why. You just don't file a form and say, here, I want to do this and pay me. There'll be a little follow up on that. So it's not an automatic going to happen, but usually it's like, this is my son, I take care of them, blah, blah, blah. okay, that's easy peasy.
So, are there alternatives to guardianship? Do you even have to come to the court to get guardianship? First of all, that person's got to be competent, right? That's my critical issue in a guardianship is the person incompetent? So if you're going to have an alternative to guardianship, you're talking about someone who is competent. So they have the mental cognition to make their own choices. They can take care of themselves and their property, okay? What you need to understand, though, with the alternatives to guardianship, it's voluntary. So your loved one can cancel it and revoke it at any time for any reason. That's usually the biggest downfall to the alternatives, okay, is that it's voluntary and it can be revoked. So what are some of the alternatives? Conservatorship. This is pretty rare. We only get 1 or 2 of these a year. Okay, so again, this is a competent person, but it operates just like a guardianship. Okay, you can have a conservator over the person, you can have a conservator over the estate. Most of the time, what this is an older person with maybe one of the conditions that impacts them physically. I would say mostly like MS or Parkinson's, where they are just getting to the point where they can't write their own checks or they need some assistance and they want the transparency of the court. That is typically the conservatorships that we see, all right? So again, this is a competent person. So it looks like a guardianship, except there's no expert evaluation, right? Because the person's competent. I don't need that. There's no guardians reports. There's no annual plans. You can have a power of attorney. If your loved one is competent enough to sign a power of attorney, they can do so. You could have a healthcare power of attorney, designates an agent for someone to make your medical decisions for you. You could have a durable power of attorney for finances, would allow you to handle your banking. Again, it can be revoked. I'd recommend that you talk to an attorney and have them prepare that because they will probably ask questions to make sure your loved one understands what they're doing. I talked a little bit already about the representative payee for Social Security. If it's just a money issue, maybe your loved one is really pretty good making their medical decisions, but maybe it's money that they're having the biggest problem with. You could just not have a guardian and have a representative payee for Social Security, and then you answer to Social Security. You could have an authorized representative for some of your benefits. You could for Medicaid, you can designate somebody to interact with Medicaid on your behalf. And of course, you could have trustees. If that's, again, if your problem is a financial one, you could just have a trust, a special needs trust, a Medicaid payback trust, and never have to come to the court. And honestly, you could have a really good support system. We have guardianships that don't even start sometimes until someone's in their 30s or their 40s. And I'll look at the person like, how did you go this long? I mean, how did you transact business? How did you get, medical care? And they're like, well, we've been going to the same doctor for 20 years. They knew me. They knew I was mom or that was my brother and my sister. And they just kept dealing with me. And everybody was on board and nobody questioned it. And we were able to go through the decades like that. But then inevitably somebody retires, right? The doctor retires. You get a new doctor and all of a sudden, again, it's like flipping a switch. Oh, no, I'm not going to give you any information. You're like, I've been to these appointments for 30 years. What are you talking about? So it happens. Maybe you don't need a guardian because you just have a really good support system. Judge, anything that you can think of before we open up to questions?
No, I think the biggest thing that Magistrate Hathcock discussed there is the revocability of a lot of those items as alternatives. And that's what makes those items not set in stone. They're always kind of on shifting ground. So some of the banks and things are difficult. We're aware of that on the financial end to work with them. I've gone head to head and toe to toe with banks on more than one occasion that this order says these are expenses that will be paid monthly. Person's $650 rent. You do not need a new order from me. Until further order of the court means until further order of the court, you pay those bills. And we've gone toe to toe. I've gone toe to toe with banks, and those aren't very pleasant experiences for the banks. But we try everything we can to try to make this as transparent so that you understand why you're doing what you're doing and these purposes, and like, oh my gosh, that Judge Dunn's just out trying to hassle me. Then he put that Hathcock woman on me to really drag me in here. And then I have to go see him because I don't agree with her. So we really try to avoid that. This is an area with the number of cases, it doesn't sound like 800 people, that's all you got. We're dealing with those cases and those individuals. That's a whole docket for a year. And these things don't go away. These are 800 cases every year sitting on my desk, on her desk, on Nikki Shook's desk, and managing those cases. We come those out the door. We don't get new points. Is in some of these things, we don't close these files like you do a lawsuit for an auto accident. Well, it doesn't get shut in 12 months. These things can last forever for us. So we take these things very seriously and are a big part of our day. And we'll take the questions now.
One more thing before we do the questions, I would say if you run afoul of some of these, like, oh, I didn't file my annual plan on time, we're not going to remove you. We go through great extremes to not remove somebody. So I'm not looking for technicalities. We will do many different things to make sure we just get the piece of paper that we need.
You have to be pushing the envelope very hard, purposely. And that's why we're the Superior Guardian. Hey, we bring it in. If you have a problem understanding a form, we're not supposed to do your legal work for you, but we will walk through that ourselves and verify things. You know, I can ask those questions. Okay, tell me, how do you spend these funds? Oh, well, did you bring the checkbook in? Let's go through the checkbook. And that's how we try to handle these matters. We do those in hearings.
And we work with other agencies. Sometimes we have guardians that are so frustrated working with a particular agency, we will get them involved. I will say typically that is a developmental board of disability. Maybe they have an issue. They feel very strongly about something and maybe their team feels strongly about something else. I would say I very typically have county board workers in the courtroom for various issues. And we can work on that. Typically, Nikki Shook, the court investigator, will almost mediate them. She'll talk to the county board worker, she'll talk to the guardian and try to, where's the middle ground? What can we figure out? If we need a hearing, we'll do the hearing. But we can also support the guardians that way. That's the benefit of having the superior guardian. We can get involved and support the guardian if it's warranted for certain things. I mean, we have the power of a court order, right? So we have that potential. So questions here in the room, correct? Anybody have any questions here?
If we file, so we're looking to go down guardianship for a juvenile, and we have to refile it 18. Like if once she comes, like if we give guardianship, we have to refile it 18.
Is this minor? Is she a child of yours?
My relative.
Okay.
Okay.
So you'd file a minor's guardianship. We want to be the guardians of this minor. Now that minor's guardianship would terminate upon her being 18 if it's a female.
But then if she has a disability,
you file again
Okay.
before she turns 18 to have it roll smoothly. The minor's guardianships that a lot of them I see are monetarily based. And the reason for that is the parents may not be available. I see a lot of minor guardianships for financial reasons. A lot of it has to do with substance abuse, mental health abuse, mental health issues of parents. And they're not capable of dealing with a child's settlement proceeds, those types of things. We've had guardianships established that, hey, my sister can't take care of her children. I'll raise her children. I need those guardianship papers lined up for me. And if it's a special needs, a child who could be severely autistic, for example, I'll be the guardian of that person. And then I may need to take that the next step to the guardianship as an adult. The similar process applies on a lot of the things you've seen here of what's going to be requested of you by the court. What's the basis? Why are you doing this? Okay. You need the guardianship to get the child in school. You just don't register a school. You don't show up and, hey, do these things. We have, the faster you bring those things to our attention, the faster we hop on those. And if you let our staff know that, hey, we're trying to get this for school purposes, great. When I was in private practice, one of the things I would do is have to go up to the city of Cleveland, and now they have birth certificates centrally housed down in Columbus, and go up to the municipal building right on Lakeside and get birth certificates, because needed the birth certificate to register a child. And we had all these situations before guardianship started to become popular that, hey, what's your power? Why should this child be allowed to live with grandma, grandpa, aunt, uncle? What's the situation there? We also need to go through the process to give you those rights. And that guardianship at a later point in time, if a parent would step forward, by law considered the primary guardian of their children, unless there is some reason as to why they cannot do it. They can move to set aside that guardianship. Those are all hearings. Those are the contested things that the court gets to decide what's in the child's best interest at that point in time. So.
Quick follow-up, because we wouldn't be blood related, we wouldn't be required to do the 6-hour training stuff.
So this is adults.
This,
Minors are different.
Right, but I'm saying like, taking that if there is.
I will, the nice thing is the court can waive that requirement whenever we feel like it.
it's a confidence level for us.
Yes, I'll be honest. So if you were appointed as a guardian of a minor and that looked really good for however long you were a guardian, I'm probably not going to make you do the 6 hours. I'll be honest. Yeah. Out of a given year, I probably only order a 6-hour maybe once or twice in the year. And most of the time that's actually blood relatives that maybe I didn't have a confidence level, especially in when they're handling money. If I'm not convinced that they really understand that piece of it or they're handling a lot, you're more likely to get the 6-hour.
Both the minor, some of the things you may see are applying for SSI for that minor. You're
already in there. Okay.
Yeah, okay. But you know, the big things are medical, getting records, and you'll be surprised how many, hazards will be tossed in your way if you don't show up with the paperwork with the seal on it and the signature of the judge. It's amazing how that opens doors. I never thought my signature would be that great, but it's apparently in some circles opens up some doors. So,
but I will say it is like your first question, you are reapplying at 18, which means the parents are getting re-notified, just like they were notified of the minors.
Okay. Yes.
Okay.
The estate as well.
Okay.
Oh, so you have to go through the state and that's a separate, and that's what's so much fun about what you're probably going through right now. I'm not trying to make light of your terrible situation.
But
you're
yeah,
looking at
just
everybody.
realize, but remember there's a hierarchy of who gets notified, all right? So if your ward, let's say he or she is 18, first question, are they married? No. Do they have any children living or deceased? No. Are their parents alive? If the answer is no, then we're dropping down to the siblings. Are there siblings alive? If there are, you're notifying them. So, and if you don't have that, then you're almost going back up to the grandparent level and going down. You could go to aunts, uncles, cousins. You think of it like a family tree. You start small and then start going out big. Somebody's getting notified. I almost rarely have a true case where there's true no next of kin. Normally somebody's got a cousin somewhere. Or we do service by publication, which is a newspaper. If you ever picked up a newspaper and you see like it looks like a notice of hearing, that's a great way to kind of hedge your bets and make sure everybody's on notice. I don't know who's who. Sometimes that's even the question. You don't even know where people are. You don't know their names. You have no idea. That's one way to do it. Does that answer your question? Okay. Yes, ma'am.
If a person is the guardian of the estate, does that include personal expenses and business expenses if the person under guardianship is a business owner?
I would recommend you give that question to your attorney. Okay. Maybe. That's the legal answer.
Yes, it would be based on what the business is and that
Right.
relationship with the business.
And how it's held.
How it's held.
Yeah.
Is it a corporation? Is the person sole shareholder?
Yeah.
Is it a doing business as? Is it individual proprietorship? I mean, that's when you get all the corporate and business law. So that's why we kind of give you that answer. So you have to sort that out first. But in theory, you as the guardian of the estate are the protector of all their assets. That means if that person has a gun collection and you're worried about that kind of stuff, well, do you come and you ask the court to maybe dispose of those things or to sell them or to have them held somewhere else other than the house? You may want to get those orders from the court and find out why. I have handguns, I have firearms in my house. So I'm not like anti having weapons, but you may want to say, hey, this is not something that we want this person to have. And that's something that you may be able to cull the herd a little bit from any flack you would get and bring that to the court. Let the court be the meanie on that, so to speak. As I tell most people when we start proceedings, you're asking me to make this decision. I'm going to preface it with my kids don't think I know how to do anything right. My wife doesn't think I know how to roll the garbage to the end of the curb the right way, but you want me to make the decision, or maybe you guys can work this out amongst yourself. And amazed how many people, when they get in those conflicts, actually get things done that way.
So it depends on how the business is held.
Yes.
Okay.
So it doesn't correlate with power of attorney, financial, which I was in the past, versus if there was a guardianship of the estate. It does, they don't correlate together, because with the business previously, I was only in charge of personal finances, and the corporate finances were done in a different manner.
I think you're getting pretty specific, and I would again tell you to talk to your counsel about that. But that does raise a question. If you have a power of attorney in place and there's a guardianship, the court has to make a decision what happens with the power of attorney. The court can terminate, suspend, or leave an attorney in place, power of attorney in place if it's in the ward's best interest. So it depends. Sometimes we don't touch them and sometimes we do. Yes, ma'am.
I have several, okay?
Sure.
Okay, we're here.
Go back to your two types of guardianship powers. You said now visitation, where before that was a really gray area.
Yes.
Our son is an adult. He scares the bejeebers out of me when he's on that computer.
Mm-hmm.
And he's allowed me to go through Facebook and delete people that I just knew he didn't know and weren't safe.
Mhm.
Now legally, I'm allowed to do that?
So our court always handled those types of issues. We always thought it flowed from our power as a guardian. We had no trouble with that. There were other courts, not Medina County, that said, we are not touching any type of visitation that exceeds our authority. So there were some courts that did, some courts that didn't. We've always handled it. Now, how the rule has changed, it's made it clear that a guardian can choose to limit who has, in-person visitation, telephone, social media, electronic access to the ward, as long as it's in their best interest. And I will say the computer should scare you.
Yeah.
It absolutely should. I have had some interesting cases. I was explaining that to somebody else before we sat down. It amazed me. I mean, this was a person who had just basic access, and how the scammers will find you. Yeah, and they were getting this person to buy gift cards, and they had a small bank account, and that's exactly what they would do, and transfer it to the scammer, who was just convinced, I'm this actor out of the show that they loved, right? I'm this actor, I love you, we're going to be together, but I need this Amazon gift card. And that's exactly what happened.
I actually talked to someone last weekend about, he's doing cybersecurity or something. I said, well, can we have some sort of a training about protecting our kids from the internet? Because they get on computers. They are going to do it. And so that's really interesting.
And it's not that they're computers, it's their gaming systems, it's their phones, it's everything. So yes, you can, but know that on the annual report, there's going to be, and this is a new line, we just started it July 1, that says, have you limited contact with anybody with your loved one? If so, who? I'm not going to generally be concerned with people like that. Where I get concerned is I'm not letting the wards see their brothers and sisters. I'm not allowing them to see any friends.
Yeah.
Those are a lot
Isolation.
A lot of this happened and kind of it came out of Stark County. The judge there was very proactive on trying to deal with this, because she had some ugly cases where someone became the guardian over dad. And congratulations, brother, you're not going to be able to come in and see dad. We're mad about something. You can't do this. And she started a program up because she had enough of these, and they funded a position to basically have an arbitrator on staff to resolve all those things. And it's it's crazy in that regard, but that's one of the things that they do look at, and that's one of the things that we try to prevent. We haven't had too many of those issues.
But I also know what you're probably going to hear. It's a rights restriction.
Yes.
Right?
It's a what?
Rights restriction.
Well, yeah, and so that's where he's an adult, and so you can't do that. But I feel, and I have never done it without his permission.
Sure.
But I want to.
Mm-hmm.
I want to get in there and say, so I'll say to him, do you know this person? Because I don't know everybody he knows.
Sure.
I mean, everybody in this county pretty much knows my son. They don't know me, but they know him. And so I always ask, but there are some I'm very clear, and I'll say, can I delete them? But I want to know if I have the right to have that ability to go in there and say, there's no way you know this person, they're in Africa, they're
Yeah.
in New Guinea, they're in
Right,
Russia, they're, you know,
Mhm.
so those are the ones that I'm really concerned about.
absolutely.
When we got our guardianship, now I'm 99.9% sure I got this right. We got both.
Probably.
He doesn't have, I think they told us it was a maximum of $25,000.
Probably.
And I don't have to file, I'm pretty sure I'll have to file reports. Am I correct in that?
Yes, so that was, again, that was a major change in the law. And even back when I was doing guardianships, it was standard procedure. You asked for person and estate. It didn't matter if their sole income was Social Security. The law changed in 2016 to say you should only give as much guardianship powers as are absolutely necessary. You're always looking for less restrictive alternatives. A guardianship is supposed to be the last resort. You really are substantively taking away somebody's rights. You're taking away their right to make their own decisions in many areas of their lives. So the law tells us we're only supposed to do what's necessary. I agree with that. I also see it, I sympathize with people that have to file all this paperwork, especially when you are handling money, right? It's a lot of paperwork.
And everything now, all of the bank accounts, all of the statements are electronic.
Yeah.
So I would, just as a heads up, you know, you have that printer, you hate to use it, you hate to kill paper. I would suggest you print out every month and keep them in a file for a year.
Yeah, I will say that's probably, if you had guardianship prior to 2016, that's probably exactly what happened. If we need an account from you, don't worry, we'll send you a letter. So if we haven't sent you a letter, you're good to go.
Okay.
Yeah.
So I mean, basically all he gets is Social Security.
Yeah.
He does work like 4 hours a week, so he's not getting a lot of money
Yeah.
anyways, but, so now I have a question back to, I think it was in your requirements after hearing, so
Okay.
page 7, the top.
Uh,
He lives independently.
Okay.
We hire a provider agency to care for him.
Sure.
At one point, there was issues. I
Mhm.
didn't notify the court, but the company, the provider agency dealt with it.
Okay.
They brought the police in. That person was removed immediately.
Mhm.
Was I wrong? Should I have notified you guys?
Technically, yes.
I should. Okay.
Technically. That being said, it's unfortunate what happens with the direct care provider. This is a very common theme. We've had physical abuse, we've had financial abuse. It's horrible. And it goes on all the time, and rarely are we directly notified of it. However, the county board in particular will notify us of the big ones. Yeah.
But for something like if there's an MUI reported, we should call you and say, just an FYI?
I would say use your judgment on that. Do I have to know about every MUI, especially if somebody is triggering those a lot because of their behavior or what have you? No, probably not. If someone is harming them,
Yeah.
a physical abuse, a financial abuse, I'm gonna want to know.
Yeah.
Yeah.
Okay. Yeah. We're in the process of talking about a special needs trust.
Mm-hmm.
Now, do we need to come to you?
Just to get it created, first step will be a lawyer who really knows how to do them. Perfect.
And get a,
Talking to, but we haven't
Get-
signed anything.
get a good one.
Yes.
Do not go out and get a person who doesn't do this kind of work, because they
We've got-
will
We-
balance it up.
Okay.
It's-
But
Yeah.
you don't,
We've
you have,
been there, we've done that, and
Okay.
they created a trust that was not proper for them.
sure.
Yeah.
Didn't sign it either, but we had other people look at it, so we need to notify you
Technically, yes.
before we sign.
Correct. It would be if you are creating this on your loved one's behalf with their money,
No.
you're using your own,
Third party.
then no, we do not. If
Oh.
But
it's
if
different, if it's the ward's money, because again, we have control over that
Oh,
as
so
superior
that's the
guardian,
difference, If it's his.
Right.
money, yeah.
unless you feel different, Judge.
No, for example, I had one special needs trust, and that we used to call these cases a wrongful birth case. Child was born and through medical negligence was going to need special care for the balance of their life. Humongous settlement, huge settlement. Never enough money to be able to take care of that person. But those are they wanted to put this in a special needs trust. Great. Let's see the trust before you execute that. Let's make sure all the T's are crossed, all the I's are dotted. And the court will then give you approval to do that act, because
And
that's,
with their money.
that was the
Right.
child's money coming out.
Right.
And I get those quite often
Mhm.
out of settlements on personal injury claims, car accident, person gets harmed very, very significantly.
Inheritance.
Yeah,
Sometimes
inheritance.
inheritance, but that's correct. That's the dividing line. Are you, whose money are you using? If it's your own, not your loved ones, I don't need to see it. If it's theirs, we're gonna need to see it. Yeah.
Just on that last one that you had, does the guardianship actually stand in for a healthcare and durable power of attorney? Is that basically the same thing?
I would say the guardian of the person, yes, is making the decisions in the healthcare power of attorney. Yes,
In the guardianship?
yes, yeah.
So we're making, like, we talk to the doctors, we go to the doctor's visits with them.
You shouldn't have to have a guardianship and a healthcare power of attorney
Okay.
in general. There are some very specific, there are some circumstances where it makes sense. It's usually in the older population. Maybe if you're trying to keep certain family members involved, you're trying to not disturb something. But generally you have one or the other.
And you'll be dealing with typically the lowest person that knows the most in the healthcare system when you go to register your person and go in for a surgery or something like that. So you have to get past that person that's working the counter first and explain the circumstance. I am the guardian of this person. I'm the, healthcare, I'm the durable power of attorney for healthcare. You have to roll those things by them. So sometimes they don't understand those things either.
Yeah, we have to put the figures in there. I just have like one or two. Have you ever had an instance where somebody who really is truly incompetent? So our son is special needs, definitely incompetent. But I spend a lot of time in this community. So I know of individuals who have had guardianships placed and revoked. Do you require a doctor's examination to say, yes, they really are competent to make that decision?
Almost always, but not 100% of the time.
Scary.
I understand.
I've seen some bad things happen when that's happened, and that's why I'm asking
Yeah.
the question, because I've seen people lose a lot of things that they shouldn't have lost because they didn't have the right person looking out for them. I think if you see something like that where you know someone's being taken advantage of, but you're a third party.
You can report that and you can report that to the court.
Mhm.
You can report that if the person is receiving services, if you're aware of that. That's why you have a court investigator. When you talked about how many, if we have all these incident reports, should I be reporting every one to you? No, but collectively you may want to assemble those for your annual report. Like, hey, here's the situation when you're giving that report for the annual. Here's the things we're going to try to provide for our person. Hey, here are all the incident reports we had last year. And so that we're aware of it. Nikki, our court investigator, and any court investigator is going to go, oh, wow, okay. That gives us a flavor of knowing that's one of our 800 people here. And what does that person have a proclivity of being like? Is this person going to be, is this a person that we never have any issues with? And oh my gosh, all of a sudden we have something that pops out. We really need to hop on this. If it's something that this is kind of a daily affair thing, that we can also, weigh that into the specifics of dealing with that particular individual.
My question too, we do see incidents where an individual becomes a self-guardian.
Yeah.
And it doesn't play out. So at that point of transition, there's no probationary period or anything of
No.
that nature.
It depends. I have. Yeah, absolutely. As a trial run, sure. So going back to the complaint, first of all, anybody can file a complaint against a guardian. If the case is open in our court, anybody can file a complaint.
What if the person is their own
They're
guardian?
self-guardian.
Absolutely. I don't care. Well, no, you're not a self-guardian. You
Yeah.
have a guardian. If they do not have a guardian in place, I can't do anything with that.
Okay.
If there's an open case, an open guardianship in
Yeah.
the court, then you can file a complaint. So you have somebody serving as a guardian over a ward.
Okay.
Can a ward be a guardian of himself?
No.
No, then you don't have a.
Then you don't have a guardian.
guardianship. Now, for example, I just had an individual who had his guardianship terminated. The basis for the guardianship no longer existed. They came forward, put forth evidence, reports, everything else. And that individual asked the court, can I have copies? Typically, we do not give the copies back of the expert evaluations. So dug in a little bit further. Why? Well, I need this for Social Security reasons. And can you get me that make that available to me for my application for Social Security for myself? Okay, that's legit. You have to come in, you have to provide us proof you are who you are, because you'll be surprised with all the public records. People will come in and hawk people down and be, hey, suddenly you're going to get a big settlement. I am your best friend. You didn't know I was your cousin Kevin. You know, wow, here I am. You know, saw you at the family. You probably don't remember me from the family reunion, but we can be best friends. And we try to screen a lot of that out.
So that when you hear someone say, I'm a
Self-guard,
self-guardian,
no.
I guess it's an oxymoron. You can't.
We're our own self-guardians. You know,
Right.
it would be, I mean, hey, look
Right.
at us. We're self-guardians.
That's not a thing.
No,
Yes, it's not a legal term.
no,
So if a guardianship is
in place.
And that has
Hold
to
on.
be dissolved through you guys.
If it's with our court, yes, there's almost always a hearing.
Yes.
Then at that time, the individual is evaluated to make sure that.
No.
I would say the only time I have not, yes, I want that expert evaluation that says somebody is still incompetent. There have been times, usually with an older population or with mental illness, where we have waived that requirement, and I'm talking like single digits.
Because the main thing is it primarily hits the guardianship of the estate, that they do not demonstrate that type of capability. But by the time that's demonstrated, you know, financial disasters are occurring.
Yeah.
Loss of waivers are occurring.
Sure.
Yes.
Guardians, vouchers are occurring.
Right.
So again, you know, so there is no probationary period, review period.
I will say, I did it actually in a case where I was guardian, and it was a developmentally disabled individual, and she was very young when I started with her. And then she's like, I want to be my own guardian, right? That's what you always hear. That's not, you either have a guardian or you don't. I don't have a guardian. You don't have a guardian. Your son has a guardian, right?
Yeah.
Yeah. Are you in probate court? That's a guardianship.
So then we don't have rights as the public, because we know these people, to come in and say, these people are not taking care of themselves. They're being endangered one way or another. We don't have a right to do.
If there's an open case
Yeah.
in the court, you can file a complaint. Has to be in writing, can't be anonymous.
Yeah. And
Okay.
if
Otherwise,
that's
you're-
the case, we're just stuck.
Yeah,
Adult
I don't have jurisdiction
Adult
over the
Protective
person.
Services, you have to.
County
make-
board.
County board, you have to start that process going with an agency to investigate that. And they would come to us and say, hey, Judge, here's what we have, and we need a petition. And quite often, we do have some groups, APS will institute. APSI, and some of the groups will come out, and institute the filing based on, hey, we have these reports, here's the person.
But I gotta have a case or you can't complain.
Yeah, but you can complain, anyone can complain about something going on in a guardianship.
Absolutely.
And we have a file, and that's the congratulations, that's why these files get really big
Yeah.
sometimes, because I didn't like how they dressed this person when they sent him to work. You know, some of these
It
things
gets
are
petty.
ridiculous.
It gets petty.
It gets real petty, you know?
Even if the disability is regressive. Meaning it definitely is not going to improve. Just become worse over time.
You can always refile.
Trial.
Unlike some other areas of the law where it's like a one and done. There's some real technical legal terms for that. Not with the guardianship. I have quite a few that may have been terminated before and they get reinstituted. The typical situation is a very, I would say where you have that happen is a very high functioning dual diagnosis person. Someone with maybe a very mild developmental disability, but then they've got the mental illness end of it. Usually with some good nutrition, some good support, employment, and somebody managing, right? They get to the point where they look like they can handle themselves. But then you're right, what happens? They cancel all of it.
Yeah.
And then they refile. It gets refiled.
Yeah,
It can always be refiled.
Bipolar individual is a
Yeah.
perfect example. Going to, I'm on my meds. I'm better now, and the the medical report says, yeah, the person's able to do everything. And then, hey, I'm better now. I'm not going to take my meds, and here we're back again. So that's just an example.
And in terms of a trial period, because of the superior court concept, we have a lot of flexibility with orders. So the individual that I had, what I did was I kind of slowly tapered my authority. I went to the court and I said, okay, she doesn't want a guardian anymore. I'm not really convinced she can handle it. The medical stuff was actually a little bit on the fence. She was very high functioning. So what we did is over a series of months, okay, I'm not going to make the medical appointments. I'm not going to deal with the county board. She's got to do it. We're going to come back in 6 months. Let's see how it went. So we can.
It really reflects in the guardianship of the estate because
Sure.
It takes a long period of time for the debt to build up and then things to start crashing.
Absolutely. Or sometimes it's spectacular and really quick.
Yeah.
Yeah. Yeah. Any other questions?
Do we have some?
Yeah. Anybody else? Yeah.
Yeah.
Okay.
Okay, we do have a couple, this goes back to a little while ago. It says, my son just turned 18. He takes medication, a family practice doctor, and he sees a psychologist. Which doctor should they use the medical forms with?
Either or.
Yeah.
Yeah, either can do that as long as it's a medical doctor, a licensed physician, or a licensed clinical psychologist. We'll take either,
Yep.
and it doesn't matter.
Okay.
So they've got two opportunities there.
I think we should respond to that.
Sure.
The next question, this is the last question that came through. It says, am I able to authorize a family member a notarized statement to make medical decisions for my daughter? I am her guardian if I'm traveling abroad.
I would say no, because only the court can divest that authority. We're allowing the guardian to be an agent of the court. And then this is a third party that we have no control over, don't know if they're, they're appropriate or not. We have not typically allowed those situations, Judge.
No, and that's very similar to the parents that are going to go on the European trip and they're going to leave the 12-year-old home with somebody and I'll just fill out this form and they can take my child and they're going to say, who are you? But it's notarized, great. That's not going to get you in the ER room. So I would avoid that. I'd come up with some other plans, maybe see an attorney on how they could deal with it.
Well, and what we could do, if you are truly going somewhere that you're not going to have access to any electronics, it could be pretty limited. We could do a guardianship for a limited time. And that was one of the slides, right? You can have a guardianship that's limited. So if you were really going away for a long period of time, you had a very medical fragile person or somebody you were really concerned about, you could take steps to allow that person just to be guardian of your loved one for a period of time. But you're going to come to court, you're going to file paperwork, you're going to spend money, you're going to have a hearing. So, and
if you're going to do that, pad in a few extra days for travel, because right now, if you're going abroad, you may not get home when you think you will.
Yeah. Any other questions? Anything else?
Anything else?
Thank you so much.
Yes, appreciate your time. Thank you. Good job.
Thank you. My paycheck will clear tomorrow?
Yeah,
Okay,
maybe.
good.
Maybe.
Fantastic.
You get paid. You
No,
get paid.
it's not
Yeah,
tomorrow.
you already got paid, haven't you?
Bless.